many judges are on the Oregon Supreme Court?
On the Oregon Supreme Court, 12?
Oh man, you're giving me hard questions today. Isn't there 10? I'm not sure.
7.
9.
I think 7.
Court.
Oh my God, 6? I don't know.
9. No, 9.
And do you know if they're elected or appointed?
Elected.
Do you know whether judges are elected or appointed in Oregon?
They are elected.
Wow. I think that depends on the locale, but I think in our state they're elected.
Should be elected.
Now, the ugly little secret I have to tell you is if you find that when you get back to your office you want to look up the answers to those, that's what I did yesterday. Here's Emily and Maryann to talk about some new cases.
Good morning.
Hi there. I am surprised that having confessed that we all checked our resources yesterday to come up with the numbers, that Tom didn't tell you. The Oregon Supreme Court has 7 judges, and the U.S. Supreme Court has 9 justices. So lest you be distracted for the rest of our presentation, there are the answers. And some of them are elected, and some of them are appointed, so it's one of those fabulous questions that you can't get wrong. The other thing I want to do before we get to content is tell you it is an enormous privilege to be presenting with our newest shareholder, and I encourage all of you to work with her because it will be the same pleasure that you have that I have each day working with her. So now if you will travel with us, because we are going to be going coast to coast to give you an update on the law. And I'm going first to the city of Hillsborough. So travel there with me, and we'll talk about a case that Tom made reference to, one that we all love, because I get to say the Ninth Circuit made a decision that was favorable to employers. And I can tell you that's newsworthy. I don't say that very much. And let's look at what happened, because honestly, the facts of this case and the circumstances are pretty extraordinary. There's a police officer who had recurring interpersonal problems, significant interpersonal problems, because they ultimately lead to his termination. He claims in his lawsuit that in fact he was not terminated for performance-based reasons, but his ADHD substantially limited his ability to work and to interact with others. As I say, he was terminated for his inability to work with colleagues. They went to trial, and the jury found for the officer. And then in a sort of amazing development, the city of Hillsborough appealed that to the Ninth Circuit and said, notwithstanding what the jury found, that is, we understand the jury thought he was disabled. We want you, court, to find no reasonable jury could have concluded that based upon the evidence that was presented. And in what's not an insignificant event, the Ninth Circuit said you were right. No reasonable jury could have found in favor of this officer. And let's talk about why. The ADA prohibits discrimination against a qualified basis on a basis of a disability. You can look at a physical or mental impairment. It has to substantially limit a major life activity as compared to most people in the general population. So that's not as compared to people with this educational level. It's not as compared to these people with this demographic. It's let's look at the general population, and now let's look at this officer. First, he claimed I have a disability that prevents me from being able to work. And the court said, that doesn't make sense to us. Here's somebody who progressively was promoted to a sergeant. That doesn't sound like somebody who can't work. And when he got his job, he had been evaluated by a psychologist and later by a psychiatrist, each of whom found he was fully fit for the job. So this is not somebody who's disabled in terms of work. The second is an inability to work with others. And here the standard in the Ninth Circuit is quite high. That doesn't mean every fourth day I'm sort of difficult. A disability that rises to the level of an inability to work with others means I can't leave my house. The prospect of interacting with people at all is really extraordinary. And the court said, here's somebody who was just plain cantankerous. And cantankerous isn't a disability. That's an area some of us need to work on. And so no disability there either. What's the takeaway? We have generally said, since the ADA was expanded, the ability to say people don't have a disability is hard. It's a broad definition, and it was intended to cover lots of folks. But we now have a case we can point to that says we don't automatically assume someone's got a disability. We get to push on that, and from time to time, the Ninth Circuit will support that.
Oh, okay.
Sorry.
No, we're going to quickly take you to Turlock, California, and this is me, and I got to go to a poultry plant. This case is a Ninth Circuit case from this year. This case involved a poultry processing worker who worked at Foster Farms, and she, by all accounts, was somewhat of a FEMLA pro. She had taken family medical leave no fewer than 15 times in the past, and during those times, she typically made that request directly to HR. In the case, or in the circumstances which gave rise to this case, she didn't do that. She had a father who was in Guatemala who was sick. She told her manager she'd like to take leave to go care for her father, but she didn't want to use FEMLA time. No, she wanted to use vacation time. Now the whole thing, the facts are a little bit messy. It was in Spanish, but HR followed up, and yes, that was indeed, she didn't want to use FEMLA time. So she goes, she blows by her scheduled return date by 16 days. No, it doesn't write, doesn't call. And Foster Farms terms her for a violation of its no-call, no-show policy. Okay, you know what's coming next. She sues for violations that her job should have been protected under the Family Medical Leave Act and California's Family Medical Leave Law. Jury finds in favor of Foster Farms. She appeals. Now, here's where it gets interesting. This should have been a really good employer-friendly decision out of the Ninth Circuit. The Ninth Circuit holds, no, in fact, her termination was justified. She wasn't under family medical leave. Her status wasn't protected at that point. But the reasoning to get there, they said that the law wasn't her leave wasn't protected because she had asked for it to be vacation time, not FEMLA time. Now, all you admin leave people should have sat up straight. You know what? That doesn't make any sense. The employee gets to choose, and how the Ninth Circuit got there was they looked at the employer's, under the Department of Labor regs, the employer has some level of an obligation to engage in an informal process to ascertain whether the reason an employee wants leave is actually a FEMLA qualifying reason. Okay, but then they extrapolated from that because of that, there must be times when the employee can ask for leave and they're choosing to use some other type of leave. And that is crazy making. That would be an administrative nightmare, and you never sort of know. It would be a lot of work to ascertain, hey, is the leave used up? Is it not used up? Employees could stack leave. You know, that's why this decision isn't actually as employer-friendly as it seems. So what should, all that's well and good, Emily, but what should I do? Well, it's actually contrary. That holding, our position is that holding is contrary to Department of Labor Reg on point, which says, and it's the first bullet in that slide, that once an employer has acquired knowledge that the leave is being taken for a FEMLA qualifying reason, the employer must designate it as family medical leave. So, at this point, the takeaway is know about the case. It's possible this language gets extrapolated. It's possible that situation becomes worse. It is our circuit. However, you can do something. take a look at your leave policies, both for paid and unpaid leave, because you have control over those. And you can specifically designate in those policies that any paid or unpaid leave the employer provides must be taken concurrently with FEMLA, OFLA, sick, all those other types of leave. So then it's clear that if an employee were to request vacation or some sort of PTO, that leave needs to, per your policy, be run concurrently with FEMLA should they qualify. We'll now take you to a UPS store in Baltimore, Maryland.
And I appreciate so much that my firm is willing to fly me all over the country for this kind of work. Young versus UPS is a case that really is newsworthy because we don't know how this is going to end. It's up before the Supreme Court. We're all going to be watching to see what happens in the spring when the Supreme Court decides this case. But here's the question that is posed. Must employers accommodate pregnant employees with work restrictions if they accommodate non-pregnant employees with the same restrictions? And here's what happens. Ms. Young works hard to get pregnant and uses leave in that process. She is successful. She is having a healthy pregnancy, but her doctor restricts her ability to lift more than 20 pounds. And she goes to her employer and says, you know, here's a restriction I've got. And the employer says, we're not going to accommodate that. You're pregnant. You're not disabled. And we'll review the policy. But the short answer is she doesn't get the accommodation. She goes out on unpaid leave. She loses her medical insurance. She comes back to work. She files a lawsuit. The Fourth Circuit looks at the circumstance, and UPS did the following. We will accommodate people who can't lift 20 pounds if they were injured at work. We have a light-duty policy that will let us do that. If you are disabled, and one of the restrictions is you can't lift more than 20 pounds, we will engage in the interactive process and talk about accommodation there. If you are a driver and you have a temporary loss of your DOT clearance, we'll talk about accommodations there. But if you went home on Saturday and you worked too hard in the garden and you can't lift 20 pounds today and you come to work and ask for an accommodation, we're going to say no. And that's no different from somebody who's pregnant. And the Fourth Circuit said that implementation of that policy, consistent with the parameters, was fine and did not discriminate against pregnant employees. So we know the Supreme Court, when they look at this case, is going to look at the Pregnancy Discrimination Act of 1978. And here's where things are going to get tricky. The court's going to tell us what we focus on when we compare a person who's pregnant with other people in the workplace. And here's why this case is so interesting. Do we compare a pregnant woman to a person who has lifting restrictions for whatever reason? Or do we look at non-pregnant employees who have lifting restrictions who are not accommodated? And can we treat a pregnant employee that same way? The EEOC has weighed in on this. They did that in July of this year. Not surprisingly, the EEOC took a very employee protective stance. They said, first of all and first and foremost, pregnancy is not a disability. Lots of people work hard to become pregnant. So we're not going to put pregnancy in a disability class. However, there are lots of conditions attendant to being pregnant that might get you into a disability. And when that happens, the analysis goes under an ADA analysis. But let's assume I don't have a disability, I've just asked for this accommodation. What the EEOC says is let's look at people with a similar ability or inability to work. Focus on that, not the source of the problem. So if you look across your landscape and there's anybody who you accommodate because he or she can't lift more than 20 pounds, pregnant employee looks just like that, they will be disadvantaged because of their pregnancy if you don't make that same accommodation. And we know the Fourth Circuit said that wasn't the case. What does that mean? It means we can't wait to come back to you with news in the spring in terms of how this actually gets resolved. And because I am a litigator, I will fully embrace this. I'm going to assist you in avoiding risks, and I'm going to say, be really thoughtful when a pregnant employee comes to you and says, I need some sort of an accommodation. That doesn't mean we're necessarily going to make it, but we are going to have a discussion about how risk-averse you are and what you want to do for some number of employees during that limited period of time that they are pregnant. We're now going to San Francisco, where Emily will report.
Okay. In this case, we're dealing with the Sheriff's Department of San Francisco. Now, the Sheriff's Department had a policy with respect to its county jails. That policy was not that unusual of a policy. And it was a policy that said only female deputies could supervise or be in the jails where female inmates were. And the purpose of this policy was to prevent sexual misconduct. There had been 12 instances of sexual misconduct in between 2001 and 2009. Those instances of sexual misconduct were what gave rise to the policy. Now, the lawsuit comes about because 35 deputies, the majority of which were female, filed a lawsuit saying that that's sex discrimination. Now, anytime you have a policy that says only a male or female can do something, that is sex discrimination, and sometimes the employer has a defense. It's in plain language, we'd call that a darn good reason. In legalese, we call that a bona fide occupational qualification. And the deputy said it's not, the reason the lawsuit was filed and the reason female deputies filed the lawsuits was because they said, hey, this impedes our ability to get the same shifts, the same experiences, the same overtime. We always have to go watch the female inmates. That's not fair. Sheriff's deputy says, hey, prohibiting sexual misconduct is what we call a darn good reason. Ninth Circuit looks at it and says, not so fast. Here's the guidance on a bona fide occupational qualification. You must show, one, there is a genuine job qualification reasonably necessary to the normal operation of the employer's business, and you've got to show that sex is a legitimate proxy for that qualification. Because the employer has a substantial basis for believing all men lack the qualification, or that it's impossible or highly impractical via individual testing to ensure that you're selecting men who have the necessary qualifications. Now, the Ninth Circuit didn't take issue so much with the fact that the Sheriff's Department could potentially show that things, but that they didn't. They particularly were bothered by the fact that the department didn't conduct any internal surveys, didn't conduct any internal studies, didn't talk to other departments or entities who had established similar or in similar situations, and basically said, you didn't back up your reason. So what's the takeaway? Well, one, actual successful bona fide occupational qualification defenses are hard to do. If you have a policy which prohibits a particular sex from doing one thing or another, take a good look at it. This is pretty clear guidance from the Ninth Circuit that not only do you have to have a really good reason, but you're going to have to really back up that reason. They didn't talk about what type of process that reason necessarily had to take, but that it had to be a good one and it had to be backed up. And now we've got an investigative report coming to you in what appears to be a mall in Tulsa, Oklahoma.
And this is another fun case for a couple of reasons. One, it gives me the opportunity to say, what you all do every day is pretty extraordinary. We mostly don't hear about it. We very rarely get calls that say, I'm having a fabulous day, Maryann. And feel free whenever you're so inclined. inclined to make that call. So mostly, folks are navigating very uneven terrain all the time, very successfully. So my hat's off to all of you. This is a case, though, that's really interesting to us because we don't know. It's another we don't know. The Supreme Court is going to make this decision in the spring. And let's talk about what happened. And this case has been going on between the EEOC and Abercrombie & Fitch for a couple of years. A young Muslim woman presents at a job interview. She's wearing jeans, a t-shirt, and she's wearing a headscarf, a hijab. And she goes through the interview. There's no discussion of her head covering. But Abercrombie and Fitch has a branding dress policy that says, and I'm not sure how it reads, but the takeaway is sort of East Coast preppy, is the look we want, and you can't wear head coverings. This applicant learns that part of the reason she didn't get the job was because she presented wearing a headscarf. And there's no question, there was no discussion in the interview about that headscarf or about the look policy as it's defined. The EEOC, when she learns from an employee of the organization that that's why she didn't get the job, the EEOC sues on her behalf, alleging a violation of Title VII, discrimination on the basis of religion. The federal district court granted summary judgment to the EEOC. That is, they found in favor of this young woman and found there was discrimination on the basis of religion. The 10th Circuit reversed in a very, very long, thoughtful decision. And the appellate court, when it looked at it, said, let's look at what actually happened in this interview. She never disclosed that the reason I'm wearing this headscarf is for religious reasons. And you have to be able to demonstrate, if you're going to bring a claim on behalf of someone alleging religious discrimination, that they have a bona fide religious belief that conflicts with the employer's policy, that the employee or prospective employee actually disclosed that there was a conflict between his or her belief and the policy, and that they were not hired because of the conflict. The court finds the EEOC failed to establish that this applicant ever informed the interviewer that her religious belief conflicted with the look. So she sat there, she didn't say anything, there's no discussion. And the court said, let's look at what your burden is as an employer, and let's liken it to the ADA. Now, I will tell you, this likening makes me nervous, because I don't think the terrain's all that clear in the ADA in terms of when we talk and when we don't. But what the court said is, employers aren't required to sort of imagine that some disability is going to create a problem. The same is true here. We don't have to conclude that the fact she presented with a headscarf is necessarily going to be a problem when we ask her to come to work and conform with our policy. It was pretty amazing that the Supreme Court took this case. There are certainly some number of scholars who are saying they took it because where things stand right now in the 10th Circuit isn't the place they're necessarily going to stand. So what do you do in the interim when someone presents with, and the commentators are talking about, wearing a yarmulke, wearing a Star of David, wearing a cross, wearing a headscarf? Does that communicate to me that if I need you to work on Sundays or I need you to work on Saturdays, that we need to have a conversation? Here's our advice, that you continue not to talk about religion with an applicant. And that if you find that there's a conflict, that you have a discussion after the offer has been made about accommodations that might be made based upon a good faith religious belief. We will certainly keep you posted. It is exciting to be at a time where we've got two big decisions coming down for the Supreme Court, and that's what makes the news so great. And we're now going to Washington, D.C. for Emily's update.
This final picture, I think it would look good in my office. Me, the Supreme Court. Okay, this last one is on one of my favorite topics, Facebook. We have a new NLRB decision this year. In it, we have a non-union employer, Triple Play Sports Bar, who screwed up on their taxes. They underwithheld on the employees' portion of the taxes, and as a consequence, employees owed money to the state. As you can imagine, they weren't particularly happy about this, and some employees chose to voice their unhappiness in the social media medium. So they complained about it on Facebook. A former employee posted, maybe someone should do the owners of Triple Play a favor and buy it from them. They can't even do their tax paperwork correctly. Now I owe money, WTF. Other employees chimed in, other customers chimed in, some of them were supportive yet vulgar, and one employee just gave it a like. So, fast forward, owner of the bar, not happy, keep in mind this is a non-union employer, terms them, two of the employees, one of which had called him an a-hole in the Facebook commentary. They file a charge, and the question before the board is it protected concerted activity, particularly the like? Unsurprisingly, the board finds, yes, it is. As a reminder, protected concerted activity is any time you have two or more employees working together for the purpose of mutual aid and protection. The board has taken a particularly expansive view on this with respect to social media and in recent years. And they found it could be a little ambiguous, but it was certainly expressing approval for the original poster's post, which it was. And then, almost more disturbingly, I wasn't particularly surprised by the like piece of it, they found that the other employee who had called the manager an a-hole, or the owner an a-hole, was also protected because it was a dispute about working conditions not directed to the general public and were disparaging of the employer, notwithstanding the vulgarity. The board also found that the social media policy was overbroad, particularly the part that prohibited, quote, inappropriate discussions. That piece, I hope you say, you've told me that a whole lot already, don't tell me again, but the board hates these sort of ambiguous pieces of prohibitions in social media policies. We've got to get those out of policies. What's interesting is the board looked to the current context to determine what the employer meant when it prohibited inappropriate discussions. And it says, well, it fired these two people for their Facebook stuff, activity, so it must be calling that inappropriate, so the policy's inappropriate. Another reason some of this is a little bit concerning is this year has been the board has weighed in on a number of cases in which they hold there's protected concerted activity in cases that could be construed or look a whole lot like insubordination. In one case, there's a Hooters case, a co-worker cusses out a co-employee in front of restaurant patrons. In another, an employee curses at the manager and calls him stupid in a staff meeting. Both of those cases this year, the board has held still protected concerted activity, notwithstanding the fact that there were some obscenities that flew around. You know, yes, they're context-based, and it's important what, the subject matter was, but the takeaway is be cautious about that stuff. If you're going to discipline or term based on social media activity or something that has some obscenities in it, that doesn't automatically get you a pass. So you need to take a hard look at that. Also, as an update, the employer, Triple Play Sports Bar in that case, filed an appeal with the Second Circuit. So hopefully we'll have some more news on what a court has to say about this expansion of protected concerted activity in social media and with obscenities. And with that, I think that's it for us. So thank you very much for your attention and time, and I'll turn it back over to Tom.